My name is Jenny Holscher. I am Division Chief of Opinions at the Attorney General's Office. And one of our functions in opinions is to assist the Attorney General in drafting his formal legal opinions, including those opinions that relate to the Open Meetings Act. And the other function that we have is to provide the statutorily required training on the Open Meetings Act. So I'm delighted to be here with you today to provide a basic primer on all things Texas open meetings. Now, as many of you know, the Open Meetings Act, which is often referred to simply as the OMA, and I'll probably refer to it as that today, it requires each elected or appointed public official of a governmental body that is subject to the Act to take a training course addressing the members' responsibilities under the Act. And that training course must be taken within 90 days of taking the oath of office or of otherwise assuming the duties of office if the oath is not required. So along those lines, one of my goals today is to ensure that those of you that are public officials meet this training requirement and that you leave with a basic understanding of your duties and responsibilities and the restrictions that are placed on you by the Open Meetings Act. And in doing that, I hope that you'll also gain some knowledge about why the Act exists in the first place. Why did the legislature feel compelled to enact these somewhat burdensome provisions in order to ensure that Texas government is conducted in the open and is transparent? And then my third goal today is to inform you of the potential liability under the Act. Now, there are circumstances when you as a member of a governmental body or your governmental body as a whole could face individual civil or criminal liability if you violate the Act. And I want you to be aware of those circumstances and to understand how you can avoid those situations if at all possible. So we're going to talk about conducting open meetings now and what you need to do to conduct your meetings in compliance with the Act. Governmental bodies may only act through a quorum of their members. So to convene a meeting, you need to have a quorum present. And if members leave, resulting in the loss of a quorum, the meeting should be recessed until a quorum is again present. We're going to talk a little bit about the rights of the public with regard to open meetings. The Act does give members of the public certain rights, including the right to attend an open meeting and the right to record any part or all of an open meeting by video, audio, or other means. Now, a governmental body may adopt reasonable rules to maintain order at a meeting, and those rules could include the location of recording equipment and the manner in which the recording is conducted. But generally speaking, you as a governmental body have no authority to deny a member of the public or the press the right to record your meeting. Now, for many of you, your governmental body is already recording meetings and you're posting them online or you're broadcasting them live maybe. But in those instances when someone from the public wants to do that as well, you have to give them that right. Now, during the public comment section, it's always possible that a member of the public may raise a topic that isn't posted on the agenda. And the legislature acknowledges this possibility and expressly allows a member of a governmental body to respond to such a comment with a statement of specific factual information or a recitation of existing policy, despite that such information was not noticed. So this provides a little bit of cover for you to at least provide some very basic response to a member of the public that has raised a topic that you didn't provide notice for. But any deliberation or decision about the subject of an inquiry that wasn't noticed must be limited to placing that subject on the agenda for a subsequent meeting. All right, we're going to move on to broadcasting open meetings and when that is required. The Act authorizes all governmental bodies to broadcast their open meetings over the internet, and it now requires some governmental bodies to do so. In particular, the governing boards of general academic teaching institutions and the governing boards of junior college districts with a total student enrollment of more than 20,000 must broadcast any regularly scheduled meeting of the governing body. In addition, A number of governmental bodies are now required to make a video and audio recording of each regularly scheduled open meeting that is not a work session or a special called meeting, and make that recording available on the internet within 7 days of the day the recording is made. So those governmental bodies include the governing body of a home rule municipality with a population of 50,000 or more, a county commissioner's court for a county that has a population of 125,000 or more, a school district board of trustees for a school district that has a student enrollment of 10,000 or more, and then certain other transit authorities or departments. All right, so that wraps up our discussion of open meetings. Now we're going to move on to closed. Now, apart from these criminal provisions in the Act, it expressly provides for civil remedies as well. And we talked about how any action taken by a governmental body in violation of the Act is voidable. Individuals may sue to prevent threatened violations of the Act as well. Now, we discussed the scenario where the executive director's termination was taken in violation of the Act and how the court voided that action. In the same way, if your meetings are not accessible to the public, or if you haven't provided proper notice, if you've forgotten to post notice or it's been posted in the wrong place, any of those accidents, mistakes, whatever you want to call it, could result in the actions taken at your meeting being voided. So you want to make sure that you are following all of the requirements of the Act, because there really can be some significant financial problems that will result if you don't follow the requirements of the Act.